Yes.
Back to mention item numbers 31 and 34, madam. It's mentioned from the other side.
30
31 and 34. Can it be after 2 weeks?
after?
2 weeks.
Okay, after 2 weeks. All right. Yes.
31.
Yes. Next.
I would like to mention one civil revision petition, Manoj, to be listed today, Manoj. There is some urgency, Manoj. Civil revision petition, Manoj.
What is the urgent?
Because tomorrow they will execute the execution, Manoj, for demarcation of land, Manoj.
When was the execution file? Petition file.
No petition was filed. The execution, they have straight away passed the order, Manoj,
Okay.
without any procedure. Manoj, one more matter, Manoj. This is a pension matter, Manoj. It has been pending, Manoj.
What matter?
Pension matter.
Pension matter.
Yes.
Motion.
Not motion, Manoj. Orders.
Orders.
Yes.
When?
Tomorrow, Manoj.
Okay.
God bless.
Lordship, I beg to mention item number 25.
Yes.
This matter may be fixed up to 2 weeks. I have taken consent from the public prosecutor.
25.
Yes.
After 2 weeks. Okay. After 2 weeks.
This stay.
Huh?
They,
There is a stay.
yes.
Who is for the PP? Who is the PP? Any objection? Had Miss R. Koil, counsel for the petitioner, and Miss T. Zini, we are PP,
Yes, Your Lordship.
APP.
APP, Your Lordship.
There is a special PP also.
He have informed me that since they have already informed him that they'll be
Who is
taking
this special PP?
Jambe, Your Lordship.
Huh?
Jay Sri, Your Lordship.
Okay. Additional PP. Mr. R. Koil, counsel for the petitioner. 2 weeks.
2 weeks.
Request for an adjournment of this case by 2 weeks with continuation of the earlier interim order passed, to which Ms. T. Jenny, London APP for the state has no objection. Yes, in view of the above, list this matter after 2 weeks as prayed for. So interim order passed earlier shall continue till the next date of listing.
Much obliged.
Lordship, I beg to mention item numbers 11, 12, and 13. Matter may be fixed after 3 weeks.
11, 12, and 13. Yes.
I'm for the petitioner.
What do you want?
Matter may be fixed after 3 weeks.
What is the matter about?
Item number 11 is challenging the legality and validity of the ex parte eviction from notice order dated 19/12/2020 issued by the Commandant Port IRBN.
You are appearing for
Petitioner. In item
petitioner
number
in all the writ petition.
in item number 11 for the petitioner, 12 for respondent, and 13 for petitioner.
Where are the counsel for respondent?
We have informed them.
On the is spread for by Mr.
3 weeks, after 3 weeks. S. Yirang.
S.
Yirang.
Hiram counsel listed after
3 weeks.
3 weeks.
Yes.
Okay.
And Lordship, item number 28. This may be
28.
after 1 week.
Okay.
28.
After 1 week. Speed कितना नंबर है? कितना sound कर रहा है? Medium में? Yes.
Lordship, this is a contempt case.
How many respondents?
Respondent is 3.
Okay. As Mr. T. Tamala, petitioner issue notice returnable in 4 weeks. Steps by both ways within a week.
May I please, Lordship?
Lordship, this is an application filed under section 438, Lordship, in respect of Michuga PS 5 of 2023, Lordship. The copy of the FIR, Lordship, they could not able to get it from the consent court because I have been informed that because of the road condition, Lord, because of the road condition, the Michuga police usually bring the accused, submit the FIR while production of the accused in the court, Lordship. So FIR, we try to get it from the consent court, Lordship, but we could not able to get it, Lordship. So I'm grab the leave of this honorable court to allow me to submit the FIR, Lordship, at the time of final hearing, Lordship. So the case of the applicant is that, Lordship. The applicant, Lordship, is being married. The complainant and the accused person, they are husband and wife, Lordship. And their marriage has been solemnized in the year 2019. And right after the birth of the second child, the applicant has been transferred to the Michuka police station, Lordship. And the Michuka police station, Lordship. Michuka. And after
you are posted there.
Lordship, as a constable, Lordship. And after he was being posted there, Lordship, he started having affairs with one lady constable, Lordship.
Okay.
And she was being informed to the complainant as well, Lordship. But the complainant, she said that, okay, you can stay with her. You can keep her as a second wife, Lordship. But the salary of your salary has to be withdrawn by me, Lordship. So it was agreed by the parties and they started living as a husband and wife. But suddenly in the month of February of 2023, Lordship, the complainant, she suddenly came to the Michuka, Lordship, and started verbally abusing to the second wife and the applicant, Lordship. And there was a Kivang decision, there was a Kivang held.
Why?
Lordship.
Why did she do that? Did you stop her from
No, Lordship.
the salary?
No, Lordship. That's not the case, Lordship. Okay. So we have
She's still withdrawing the salary.
Lordship. Because the children and the wife, the first wife, Lordship, the complainant, that is the complainant. I'm the one who was look after them, Lordship. And my salary is withdrawn by the first wife only, Lordship. And thereafter, Lordship,
then how are you maintaining yourself and your second wife?
Lordship, second wife.
How are you maintaining?
Lordship, that's with the bigger salary, Lordship, the 70% of the salary used by the first wife only, Lordship.
Okay, 70%.
70 or 80%, Lordship.
So perhaps she wants the entire salary.
Lordship.
Is not it? That is why.
Also, thereafter the meeting was there was a Kivang decision, Lordship. Kivang meeting was held at Dapurijaya, Lordship, wherein the applicant he clearly stated that since it was agreed by the first wife, Lordship, from the beginning, Lordship. So therefore, he won't be able to leave the second wife, Lordship. He decided to keep both the wife, and thereafter the complaint has been initiated against the applicant, Lordship. And invoking section is section 498A and 506, Lordship.
So yes, Jenny, you produce a case then.
Yes, Your Lordship.
Lordship, in the meantime, Lordship, since I'm in Khonsa right now, Lordship.
Khonsa.
Lordship, no, I'm presently posted at Michuka, Lordship. But my second wife, family members, they are staying at Khonsa. And the second Kivang decision, which was supposed to be held on
Second wife is at Khonsa.
Lordship. See, now after, before the complaint was initiated, Lordship, she was posted to the Khonsa again.
Oh, she's also okay. Okay.
Constable, Lordship. Lady Constable, Lordship.
You are from?
I beg your pardon.
You are from Michuka itself?
No,
No, Lordship. I'm from Dapurijaya, Lordship.
Dapurijaya. Your wife?
Wife, she is also from Dapurijaya, Lordship.
And the lady constable?
She is from Khonsa, Lordship.
Khonsa.
Lordship. Lordship, now the meeting which was the local Kivang, Lordship, which was supposed to be held on 10/7/2023, this month, Lordship. But before that, the complainant has filed a complaint against me, Lordship. Now I have an apprehension that, Lordship, I might be arrested by the police, and I'm ready to cooperate with the police also, Lordship, because since this is a family matter only, Lordship. And if I get arrested, Lordship, then my service might get suspended, Lordship.
Had this the T government competition and T Gini for the APP for this. This is an application. This is an application filed under section 438 of the CRPC seeking pre-arrest bail by the petitioner in connection with Mechuka PS case number 05/2023 under sections 498A/506 of the IPC. Post of. Though the FIR, though a copy of the FIR pursuant to which the aforesaid Mechuka PS case was registered has not been annexed. The counsel for the petitioner has submitted that the aforesaid Mechuka PS case number so and so was registered on a complaint on an FIR loss by the petitioner's first wife. What was the nature of FIR? Any idea?
Well, Lordship, since the parachute of the Lordship section.
The FIR was lost by the petitioner's first wife. First wife. (498) is cruelty. No?
Lordship, cruelty, Lordship, murdered out by husband and relatives of the husband.
Was by the first wife of the petitioner because of the situation that has arisen because of the petitioner having an affair or something. Huh?
Lordship, now the applicant is already decided to keep the second wife also, Lordship. Because it was initially approved by the first wife.
Applicants relationship with one lady constable of the Mechuka PS.
Earlier, Lordship. Now
Okay.
she posted to
All right,
constable.
only lady constable. Poster. Having got the learned counsel for the petition, as well as Mr. Tizin Lalit, APP, let case diary of the Mechuka PS case number so and so be produced when?
Your Lordship, if scanned copy of the CD may be called for, because
Huh?
since the road conditions is not there towards
When?
the scanned copy of the CD.
Scan copy?
Yes, Your Lordship. Because if the scanned copy, in the sense they send in the
Alright.
mail of the
Case diary or the scan copy of the case diary
Yes,
be produced when? 24th?
on
Today is
20
what?
On 20, Your Lordship.
Huh?
20 of July.
Today is what?
Today is 13, Lordship.
Oh, 13.
Lordship.
All right. 20 July,
Yes, Your Lordship.
20 July, 2022. Full stop. Till the next date fixed, in the event the petitioner is arrested in connection with Mechuka PS case number so and so under section so and so, the petitioner shall be released on a bond of rupees 10,000.
Deeply obliged.
This contract.
My lord, in this matter, just now I've been furnished with a copy of instruction by my learned friend, my lord. From the instruction, my lord, it seems that that 18 October 2022 DPC was not inclusive, but conclusive. There was no conclusive, and therefore, in continuation to said DPC, again it was held on 20 June 2023, my lord. So, in view of these subsequent development, my lord, I beg to withdraw this writ petition as not fresh, but however, my lord, I may be granted liberty to file a fresh if so advised.
Mr. T. Tagan, counsel for the petitioner, and Mr. D. Kandu, standing counsel for the land management department. Pursuant to the order of this court dated 27/6/2023 and 12/7/2023, Mr. Kamduk, the standing counsel for land management department, has produced a written instruction dated 12 July 2023, given to him by the Director of Land Management, Governor Arunachal Pradesh. However, it has been stated that the earlier DPC meeting held on 18/10/2022
Yes,
was not remain inconclusive, isn't it?
yes, yes.
Also, however, in continuation of the aforesaid DPC held on 18/10/2022, another DPC meeting was again held on 23/6/2023.
Yes.
Isn't it? Which the recommendation of which is on the submission for the decision of the authority. Full stop. In view of the above, Mr. Tagun, counsel for the petition, seeks to withdraw this writ petition with a liberty to file a press if so advised. Writ petition is dismissed and withdraw with a liberty granted to the petitioner to file a press if so advised.
Deeply obliged.
Please, Lordship.
Hmm.
My lord, this is pertaining to non-payment of bill,
Hmm.
1.48 crore. Now, this is equally covered by two judgment passed by this honorable court.
Where is the admission?
My lord, page number 16,
16.
in excerpt 3. My lord, name of work is from Kenewa to Nampe, stage 1. Sanction amount is coming. Then the physical achievement, 98% completed. And my lord, this is pertaining to May 2022. And I have completed the work. And amount is 148.37 lakhs. So my lord, at page 17 is the 12 list, name of the projects, road, which were the payment stop order were issued. The petitioner is at page serial number 10 of the page 17, my lord.
Hmm.
And this equally situated cases, serial number 7, he had filed a petition being WPC number 194/2022.
Okay, let the issue notice. Will issue notice?
Yes. Otherwise, just in the last occasion, only instructions were sought in the second writ petition. The same stand will be there because Your Lordship,
No.
in page 21,
In such a matter, there has to be an affidavit. If in the affidavit, if they admit only, then only we can pass a matter. In earlier case, affidavits were filed,
it will be filed,
not denied.
not denied.
On the top of it, the learned counsel also admitted, yes, we have to pay. Then only writ court can go. Otherwise, not on instruction or something. And
yes.
councils cannot give concession also on without there they had considered because of the affidavit. In the affidavit, they had not denied.
In the second case, on the basis of this first case, instructions were sought by Mr. Tarak. And on the basis of that instructions, the second case was disposed of. That can also be done, instructions.
But that may also difference.
Let there be an affidavit.
Let it-
How Chief Personal comes for petitioner. Mr.
I'm for respondent number 1.
Then got to DSG for 1. And Mr. G Tarak, standing counsel, no? RWD for 2, 3, and 4. You should notice
3 and
it's another 4 weeks. Just extra purpose.
Obliged, Lordship. But, I'm extremely sorry. But in that order, if an observation can be made that the pendency of this shall not be barred if
Pendency of this writ petition shall not be a bar for the respondent authorities to release payment to the petitioner if the petitioner is entitled to such a payment under the law.
yes, obliged, Lordship.
Yes.
May I please also?
Here is an application under section 401 and 397 of Criminal Procedure Code for quashing and setting aside of impugn order dated 9/5/2018 passed by the learned session court UPA. So here in this, at the very outset, the brief fact of the case is that the here alleged accused have conducted a audit in his residence, and the victim herein, deceased person herein, he was the salesman. He was working as a salesman in his wine shop, and during the course of audit, conduct of audit, that is on 1/3/1999.
You're challenging what?
Yes, Lordship.
What are you challenging in this petition?
Petition is here, now I am challenging the board of doctors who have prepared the post-mortem report as a suicide, and they have coined the suicide theory, whereas this is the clear case of, there is a prima facie case, entire evidence, circumstantial and ocular evidences indicates, entire report indicates there is it under falls under section 302.
You are challenging the post-mortem report.
No, I am challenging the board of doctors who have been discharged from this instant case. They were implicated. They were implicated, and they were implicated under section 120B, that is for punishment for criminal conspiracy. Then section 201, that is causing disappearance of evidence of offense or giving false information to screen the offender. That is one part. Then section 218 is the public servant framing incorrect record or writing with intent to save person from punishment.
Just a moment. The petitioner had filed an FIR against those doctors.
Yes.
Who was in the board who prepared the post-mortem report. Case was registered.
Yes. No, Lordship, here it has to be very clear. The FIR was lodged by his cousin brother. Then in the subsequent development, no doubt they were initially, their names were not there. In the subsequent event, supplementary charge sheet will filed by the IO concerned. Then accordingly, they have been implicated in this section. Respondents were implicated in the board of doctors, three board of doctors.
Just a moment. What is the matter?
My lord, the doctors, these 3 doctors who conducted the post-mortem report, they were discharged on the stage of consideration of charges, citing lack of prima facie evidence against us. That is what he has put to challenge. At the stage of consideration of charges, these 3 doctors who were in the board who conducted the post-mortem, they were discharged by the learned trial.
Were they accused? Doctors were accused.
Yes, because of pressure, madam. In any case, madam, what I would like to point out, for your lordship's consideration, no material is enclosed with this petition. No material is enclosed with this petition to come to any finding. Either the records will have to be called for, or otherwise we will have to file it. 161 installments, nothing is here. And even the impugn order that he has, my learned friend has annexed, is
Which
not
is,
complete.
which is the impugn order?
That is at page 36.
36.
But it appears, my lord, pages are missing. In my copy, it starts from probably given the idea.
Record is not called for.
No,
So,
nothing is enclosed with the
What is
petition also.
the status of this case?
In fact, there is also I wanted to point out, what I am given to understand, my lord, in fact, that was in 2018. Trial has been going on for a long time. And to my understanding, my instructions, in fact, lots of the PWs have in fact turned hostile. And most of the PWs, my lord, has turned hostile in this case. Even that record may have to be required. The learned trial court came to a prime finding there is absolutely no material on record against us.
in this regard, Lordship, my prayer would be, since the trial court, they have the file record there in the trial court. The matter is subjudiced. So my prayer would be at this stage, record may be called, Xerox copy of the, or scan copy of the record may be called for better appreciation of the matter in hand.
All right.
Yes.
Sessions case number 32 of 12.
Yes. My lord, now it might have changed. Now it has been, this case has been transferred to various courts because of the presiding judges having appeared for the accused person, main accused person. This was here at UPIA. Now it is at Alo again, my lord. That we'll have to find out.
Now, where the case is pending?
Trial is at Alo.
Here.
Yeah.
Here before the session court. UP.
Yeah. What is the case number?
Case
32.
Session case number is.
If it is here, it should be 32.
No, since 2018, I think it is here.
Yeah,
Maybe.
it is a session case number 32 of 2012.
Okay. Ms. D was it? Counsel for the petitioner. And Mr. D. Pangal, counsel for the respondents 1, 2, and 3. Call for the scanned copy of session case number 32/12. State of AP versus Izum Karawak and others under section 342, 323/304 IPC from the Sessions Court, UPIA. Listed as and when the scanned copy of the LCR is received.
But this matter is in session of the Honorable Apex Court.
Okay.
Where is that? In item number 5, my lord, the Honorable Apex Court have state the division bench judgment rendered by this Honorable Court, and so therefore, my lord, I'm furnishing the copy of this, and the matter is has been stayed, and I have checked up the Supreme Court website. It says the matter is likely to be listed end of this month. No specific date is given. And this entire bunch of writ petitions are connected, challenging the impugn order passed by the State Information Commission.
Then what order shall we pass today?
Today we will list this matter on disposal of the case by the Apex Court.
Interim order of this court has been stayed.
Stayed.
But the proceeding of the writ petition has also been stayed.
Yes, yes. But one connected matter, this item number 5. There the stay is granted. So the meaning thereby, the entire writ petitions are, adjudication of the entire writ petitions are under session of the apex
All
court.
right, learned counsel for the petitioners. No, learned counsel for the parties submits that what is pending before Supreme Court? Order pass.
My lord,
What is pending before Supreme Court?
this item number 5.
Item number 5.
Basically, my lord, what had happened in this case,
Ah.
there is an impugn order by the State Chief Information Commissioner, State Information Commissioner, directing the
Okay, all right.
respondents to disclose the information not
All right.
prohibited under section 8J of the information.
Learned counsels appearing for the parties submit that the subject matter of the litigation in this bunch of writ petitions is pending before the Supreme Court. Also, the Supreme Court, and it is, sorry, post up. In that view of the matter, now the council upon party submits that all these writ petitions may be taken up after the Supreme Court after the case pending before the Supreme Court is decided.
Yes.
Accordingly, the council of parties press for listing of this case after 6 months, 1 year.
No, my lord.
Earlier we had listed, there is an order for listing it for 4 months. So after
6 months.
after
Fine.
7 months it has come.
Yes.
So we listed after a year.
No, my lord, 6 months.
months.
Let us see.
Okay. 6 months.
Interim orders to continue.
No. If the Supreme Court has said what can we do? Huh?
It's fine.
As prayed for, listed after 6 months.
Aye. My lord, the fact of the case is that there was a land dispute between two family members, and thereby the impugn order was passed by the additional deputy commissioner in exercise of the power under section 145 of the CRPC. The case involving is purely civil in nature, my lord. So therefore, the learned additional deputy commissioner ought not to have decided the title in exercise of power under section 145 CRPC. My lord will kindly come to page 17.
Who is correspondent number 2? Service report registration of the received from us. Yes.
Okay. The next is
No, service was completed, but no any vakalat namna spell.
All right.
Yep.
Yes, which is the impugn order?
impugn order is at page 17, my lord. Or my lord, maybe afford one more chance to the respondent number 2.
All right. Administrative Travel and Council for the petition. And Mr. G. Tado. One APP for the state. None appears for the respondent number 2, despite service of notice, as indicated in office note dated 28/3/2023 and 16/5/2023. In view of that, and in order to provide one more opportunity to the respondent number 2 to represent to represent that this matter will listed after
4 weeks.
4 weeks.
Interim order to continue.
Interim order passed earlier, so continue till the next date of listing.
Much of. Oh, my lord, till disposal?
Huh?
Till disposal?
No, till next date. Next date, the case itself will be disposed of.
Grateful. Let it be in the admission column. To be remain in the admission column. Grateful.
This is a termination matter, my lord. Mr. Tazum just informed me that he has gone out of station.
Huh?
Mr. Jamo, who appears for the state respondents, just informed me that he has some difficulty and went out of station.
Okay.
Can this be after 2 weeks then?
But Mr. Deep counsel for the petition, none appears for the respondent. In view of the listed after
2 weeks.
2 weeks.
Made the judge.
Yes.
My lord, this is a matter, my lord, wherein the circle officer, without any jurisdiction, my lord, constitutes a committee, some sort of arbitration proceedings by unilaterally. And thereafter passes the impugn order wherein it comes to some additional findings without giving me any opportunity. If your lordship deems it fit for disposal, I will place the case. If your lordship deems it can be taken up for
Yes.
disposal. My lord, if your lordship may kindly.
Therefore,
place-
respondent number 5.
Yes, sir.
If your lordship kindly have page 24.
24. Is the impugn order? No.
No, man, not the impugn. I'm just pointing, I will not bother your lordship, sir. This is a deed for distribution of property between the family members of let Tapita, sir. Respondent 5 is my elder brother, in fact. Here, my lord, I am concerned with this at page 25. The plot of serial number 3, my lord. The plot of Jhum cultivation land at 3 km from Dapuri towards 0, known as Buriorga, shall go to Sri Kekpi Pijumta, sir. That is me. Now, thereafter, my lord, as a matter of abandoned concern, a gift deed also was executed at page 26. Thereafter, my lord, it appears some complaint was lodged by my elder brother, and that is how this so-called Parvana came to be issued at page 32.
Yes, you want to say anything? You want to say anything?
Lordship?
You want to say anything?
No, no, no. After my senior submission, I will submit.
All right.
Page 32. This is a re-Parvana, it seems. 30th October 2019. This is by the circle officer, Gapen Circle.
Re-Parvana?
Re-Parvana. It appears something was issued earlier. I have not received it. As the land dispute case between the above named parties has been sub judice pending litigation in the court of Gapen Administrative Circle, and complainant has filed a petition in this court for conduct of early hearing of this matter. That itself is misconceived, my lord. After the judicial separation, the circle officer has no jurisdiction. And as such, the date was fixed. Now, my lord, your lordship will see it below. Both the parties were government. He, my lord, unitary selects names of Gaon head governors of different villages. Then I object to this at page 33.
Page 33, you objected.
Yeah, I object. Then my lord at page 34 issues it again. This report is continuation of earlier such and such. As such, both the parties, as such case is refixed on such and such. Both the parties are directed to attend positively, along with witnesses, if any failing which necessary action shall be taken as the default as per law. Sri Tapu Baja, HGB will preside over the Kabang sitting and Sri Tama Baja shall moderate the hearing and submit the report to this office for further necessary action. He again selects all these persons, 9 persons. Copy 2. I again object to that at page 35. But at page 37, this is again issued. Similar line, and 11 persons were unilaterally appointed. Then ultimately the Kabang decision is at page 40. The type copy manner starts from 38. They divide the land between us, the respondent 5 and me. Then my lord will kindly have that impugn order at page 46.
Land has been divided by page 40.
Yes, 38.
Okay.
40 is the type copy, or translated copy. Page 46 is the final order by the circle officer. Heard and decided by the HGBs and GBs of Gapen Circle, Kamle district, in relation
46.
46.
Yes.
This is by the circle officer. Heard and decided by the HGBs and GBs of Gapen Circle, Kamle AP, in relation to land dispute between such and such, on such and such. While taking into consideration the facts like absence of any known will or instrument of gift deed executed against the said property in favor of any of the claimant brothers, and also eyewitness account Sri Pengata sir, wherein Sri such and such comes sole legal success of Sri such and such, had partitioned the said property equally between the two brothers during her lifetime. Therefore, it was decided in local Kabang that eastern facing side of the partition is hereby awarded to Sri such and western side to such and such. The gift deed executed on such and such in favor has been cancelled on 17 May 11 on the ground of territorial jurisdiction by the JMFC Tribunal itself.
So by
that is
this,
incorrect.
By this order, the entire land has been given to.
Yes, divided.
This.
And this finding.
Page 40 had divided the land.
Yes.
So he has given the entire.
Yes, and he also comes to a finding that the gift deed was cancelled. That no proceedings has been held. The gift deed was never cancelled. In any case, my lord, how can he, the circle officer, my lord? It was neither an arbitration proceeding. If it was an arbitration proceeding, we would have been given equal opportunity. It was totally without jurisdiction, my lord. If the respondent number 5 has something, my lord, let him approach the civil court.
Yes.
My humble submission.
Land is with you.
No, I have sold it.
Oh, you sold it?
Yes.
To whom? Third party?
Yes, third party. That I have stated in the reply also. This was, my lord, in fact, after my mother died, my lord. This was way back in, my lord, 2000 and, just a moment, my lord.
When did you sold the land?
2008, my lord, this was a partition. Now in 2018-19, he is coming to this. This was on 15th October 2019. I sold the land to one Sri Robin Mara.
15/9.
October, yes, 10.
15/10/2019.
Yes.
To one Robin
Mara, yes.
Mara. Then this Keva or Kevang, I don't know. What is this? 40, page 40. That settlement was made on 28th October 2020. After you had sold.
Yes.
Then how could the land, how the land could have been divided between the
that is what, my lord.
Yes.
If this is my elder brother, my lord, unnecessarily is doing all. If there is some grievance matter, let him go to the civil court.
My humble submission, Lordship.
Totally without judicial lordship.
Since the petitioner is basically aggrieved with the CAVA decision and the settlement order passed by the circle officer. My humble submission in respect of this, since if the petitioner is aggrieved by the CAVA decision, there is a provision under 46 of the Assam Frontier Regulation Act, where the petitioner can file an appeal, or either this is a land disputed case. Either there is a other alternative remedy where he can file a title suit. Because Lordship now read court, the issue, disputed fact of question issue involved in this case, it's difficult to decide by this read court. Therefore, my humble submission, the petitioner should ought appeal before the appellant authority instead of in state way approaching before this honorable court. That's my humble submission. And rest, I will rely whatever the respondent government circle officer, they have filed the affidavit in opposition. In that point, I will rely. Rest.
Where is the land now?
Then, because land has been, the petitioner's part, he has already sold out.
The petitioner's part has been sold out. But he says he has sold out the entire plot.
But without knowing, without informing me, we are brothers, we are three brothers. We are three brothers. I am the eldest. I am the eldest. Without knowing, in this, after filing this, after filing this petition only, I came to know that he is sold out.
Yes, Miss. What affidavit you filed?
Chief,
Depending your order.
give deed has been cancelled, Your Lordship, as per our affidavit, Your Lordship.
Which has been cancelled?
Give deed, Your Lordship. Give deed executed by the CEO.
No. How could you? How can you justify this order? At page 46, 11th March 2022.
CEO has just endorsed the
Give deed may
decision.
have been cancelled, may not have been cancelled.
Yeah.
What business he has to do with this?
He has just approved the settlement done by the Kawa, Your Lordship, Kawa decision, done by the Gaubura and head Gaubura, Your Lordship. He has not taken the decision, Your Lordship. He did not tried the case, Your Lordship. It is only the Gaubura's, Your
So,
Lordship.
Mr. Gyati, we set aside this order of the circle officer only, and will not interfere with this settlement agreement.
Yes.
And we will leave the parties.
Yes, Your Lordship.
My lord, the
Settlement
settlement,
is-
agreement was pursuant to the direction of the circle officer. That has to go, my lord.
Oh, is it?
Yes.
Okay.
He constituted it. A learned friend is not submitting it.
SD,
Page 34, not 34. The last one is page 37. This is not the proceedings under section 40 of the 1945 regulation for filing any appeal. Page 37.
37.
Yes.
Yes, 28 February 2020.
Yes.
Yes, true.
He has
Yes,
constituted.
Mr. Gyati. Can circle officer constitute a forum to settle the land dispute under the AFR?
Yes, Lordship, definitely.
Let us see.
Why? Because
Let us see AFR where circle officer can, where circle officer can constitute a forum.
Lordship, to my understanding, since this circle officer, they are because usually in organization, practically.
No. We are not concerned with usually. We are not concerned with practically. And these are not relevant in the court of law.
Yes, Lordship.
If you can show that circle officer has any power under AFR to constitute any forum for settlement of the civil disputes, then we may examine further.
Therefore, Lordship, he didn't decide. He only endorsed to the village authority. he didn't decide. He only ordered the village authority to take up the matter under AFR.
Yeah.
He didn't trial any case. Lordship, my humble submission, the circle officer, he didn't trial the case. He only endorsed. When the complaint received, he endorsed to the village authority.
Can he endorse?
Yes. And after the Keva decision,
Let us see that. Let us see that. If he can endorse, whom he can endorse? See, it is a very, there is a fundamental flaw here. Even if there is such provision. It is better for the lawyers to keep away from the AFR.
anyhow, the issue involved disputed question of faith involved the land, and it's difficult to decide by the read court. My humble submission, if my senior agree with me, let this matter may be disposed and direct both the parties to go for the title suit trial because it's a trial.
But
The
this
liberty
is-
to do with him.
But this is to go.
Yes, okay.
I am not raising a single disputed question of fact. I am only on the constitution and the consequent decision. In my lord, at page 18, I have shown these Gaubras are all from different villages. And how can he unilaterally, under what provision he can unilaterally pick them?
Therefore, it's need a required trial, Lordship. Issue
What?
involved.
Mhm.
Therefore, the issue involved required trial.
Trial.
Yes.
With the greatest respect, my lord, the issue that I have raised, how does it require trial? The dispute, the land dispute, he may go to trial. I have no issue.
No,
with
he
that.
is saying the dispute requires trial. That is.
Yes, yes, maybe he should go.
So, somebody can do that.
I've impugned all these parvanas in the settlement order and the consequent order by the circumstance.
Because we are three brothers, because only the one brother, he cannot sold out whole land. We are three brothers. Equally, we have to do.
My lord, the property was divided. He have not even contested that. But I am not on that. Your lordship cannot look into that.
Therefore,
I cannot make an argument that the land was given to me and all these things. Though I have annexed the settlement deed.
Who is respondent number 3? Circle officer.
Yes.
He has filed affidavit and you have also filed affidavit.
Yes,
Yes,
also.
Lordship.
His only contention is that there is an alternative remedy.
But, okay, all right. Mr. D. Pangalana, counsel for the petitioner. Mr. Ms. R. Russell, I'm a governor advocate. For respondent 1 to 4, I think. 1 to 4.
1 to 4.
Ex-Gyati for 5.
Yes, Lordship.
This writ petition is directed against settlement agreement stroke Kevang decision dated 28 to 2020.
page 46.
What is the name of disputed land?
Bur Yorba.
Huh?
Bur Yorba. B-U-R dash Yorba. Y-O-R-B-E.
B-U-R.
Yes. Dash
Bur dash
Yorba. Y-O-R.
Y-O-R.
Yorba. B-E.
Y-O-R.
B-E.
B-E. Yorba.
Yorba.
Bur Yorba has been mentioned in this Kevang settlement agreement. No. They have said only disputed land.
Yes.
Where this name of the land is found?
Then you also will find at page 46. Yes.
No,
in the
no, 46 is a circle officer.
circle
order.
observer.
Before that,
Before that, my lord, yes,
In
at
the-
page 34, your lordship will find in the
the
Parwana.
37 Parwana, it is there.
37, just a moment, my lord. Yes,
Yes, yes. B-R.
you use R-E.
R-E.
Yes.
Okay. Yes. Whereby the disputed land called B-U-R-E dash Y-O-R-B-E between the petition and the respondent number 5 has been equally divided.
Yes, divided into two parts.
Okay, has been, we'll say equally divided.
Yes.
Equally divided. Posted. Also put to challenge is the order dated 11th March 2020. No, settlement order dated 11th March 2020 issued by the circle officer Gapen, District Kamle, by number at page 46. However, the disputed land called Bur Yorba has been decided in favor of the respondent number 5. Correct?
They divided basically.
Divided.
Huh?
Divided basically.
Oh, divided, here also divided?
Yes, yes.
Okay. Equally, okay. Again, divide, he has
Yes.
basically uphold.
Yes.
Okay.
And thereafter, additional finding is that the gift deed has been cancelled.
So he has reiterated what.
What
this,
is the settlement order is there with additional just with an additional ground.
And how the Kevang will be held under AFR?
Kabang Manor interview section 40 Manor actually is the party should approach the village authority. My lord knows prior to the amendment, village authorities are the jurisdiction only in respect of their own villages. Here is appointed persons from.
Oh, your contention is that this members comprising of these village authorities are from different villages.
Different villages. This neither an arbitration proceeding nor a proceeding by the village authority.
Have you replied to that contention?
Only thing he says this is a Kabang decision 46.
Government has replied in that contention.
Ah.
Government has replied.
Since Your Lordship, the complaint was filed before the CO, Your Lordship. So he has forwarded the complaint to the Kawa, Your Lordship, for amicable settlement, Your Lordship. That is what he has only done, Your Lordship, CO.
It is not a forwarding, my lord. It is a constitution of members.
So you have not denied that these GVs are from different villages.
No. They have not.
No, we have not denied. In fact, we have, government have replied that since both the parties, we have land in Kamle, in Upper Sumusri as well as in Trivin, 3 districts we have land. So therefore, these different villages, Gambura, they are also right person who can decide the dispute. That was the contention of the respondent number 3. We are not outsider since we have land in 3 districts.
There's nothing like that on record.
In Your Lordship, paragraph 23, Your Lordship, we have stated in page 13. Page 13.
Affidavit.
Yes, Your Lordship, last paragraph. Page 13, paragraph 23, Your Lordship. In the instant case, Penga Tasar, head Gaubura, Siki village from Tirvin, head Gaubura's village authority has pointed out in this para at serial number 126R from Gepen jurisdiction, Your Lordship. They were from the same circle, Your Lordship, who before declaration of Kamle district were very much under the jurisdiction of the Apurija Sadar circle, and since many years, they are hearing all such disputes that abundantly experienced and mature and decides case dispute in number of cases. That is what we have stated in our affidavit. They are from the same circle, Your Lordship, Gepen.
This decision was rendered before civil courts had come into force. Let's stay order.
Yes, stay order.
We'll do it some other day.
Otherwise, but totally without jurisdiction. How can he constitute a forum? Non-existent forum. The order clearly speaks, and London friends are just
Where is the
submitting.
land?
There is also a ground. It is not under Gepen circle. It is in Dapurjo town area nearby. There is no village authority. There is no village authority there.
No, but you said you have sold it.
I have sold it, yes.
Without informing own brother. I'm the eldest.
Okay.
I am not on there.
Suppose you win the case. This writ petition dismissed. How will you get your portion of land?
So my humble submission.
That is why you should have.
Whatever decision should not be set aside.
No, that's what I'm saying. If it is not set aside, then how will you get back your portion of land? He says it is with one now, Robin Mara.
So the petitioner ought to file, if agreed the Keva decision, ought to file the appeal and or either for the title suit. Because it's required trial.
I can't believe this. Is this a decision by the village authorities that contemplated under the 1945 regulation submitting just like that?
In trial case, even the who purchased, he can be also made a party.
Why don't you do that? Why should I do that?
Mr. Lee Bangladesh petitioner, I was, had accepted. Hearings have been exchanged. Let this matter be listed after 3 weeks.
Interim order.
Interim order pass, I'll just continue till the next date.
Okay.
May I please, ma'am? Under your respondent authority has filed their affidavit, but private respondent is yet to file affidavit.
Private respondent yet to file affidavit.
Yes, 4 and 5. I think 5 did not appear any, not represented by any counsel.
Respondent number 5 has not yet been served. What is the matter?
It's a promotion.
Promotion.
Yes. Yeah,
But service is not complete on respondent number 5.
yes, my lord. Therefore, my lord, let the respondent number 4 be filed their affidavit. Meantime, I'll take precedent.
Who appears for respondent
My
number
lord, I am
4?
appearing on behalf of respondent number 4, my lord. I will file the affidavit.
When? How much
Maybe,
time?
4 weeks time may be granted.
Or Mr. Keter, counsel for the petitioner. And Mr. M. Kato, counsel for respondent number who press for respondent 4, who press for any granted 4 weeks time to file counter affidavit. Listed after 4 weeks.
Deep level.
My lord, here, private respondents once appear, but as of now, respondent number
My lord,
2.
I need some time to file my evidence.
File your affidavit.
Yes, ma'am.
You are for which respondent?
I'm for the respondent number 1.
Respondent 1.
Yes, ma'am.
How much time?
Maybe, my lord, 3 weeks, my lord.
What is this matter about?
This matter is regarding, my lord, there was a domestic violence case in CGM, and whereby my hotel resident has been given to my son-in-law, my lord. So there was an interim order regarding that ex parte order, my lord.
And who represents respondent number 2?
Has filed, I think, respondent 2 has filed their
Okay,
affidavit.
Mr. K. Tari, counsel for the petitioner. And Mr.
The other one.
D. Ado, counsel for respondent number 1, who pressed for any granted how much time?
3 weeks, my lord.
3 weeks time to file response.
Yes, ma'am.
Listed after 3 weeks as paper.
Interim order.
Interim order pass, I shall continue till the next date listed.
Much all.
My pleasure. So we are in fact, we have taken steps upon the respondent number 2, my lord. And the service report in respect of respondent number 4 is still awaited. So another, my lord, 3 weeks time may be granted. In the meantime, my lord will take also fresh steps to service upon the respondent number 2.
Here for whom?
I'm appearing for respondent number 1, 3 and 4.
3 and 4, my lord.
As Mr. M. Kato, counsel for the appellant, and Mr. M. Bozil, counsel for respondent number 1, 3 and 4.
1, 3 and 4.
And you like to take fresh steps?
My lord.
In view of the office note dated 11/7/2023, Mr. Kato, counsel appellant, press for granted 1 week time to take fresh steps on respondent number 2 by registered post with any as well as visual process. Listed after 4 weeks.
My lord. Deep level.
My lordship,
Yes.
pleading is been completed. So matter may fix for admission.
What is the matter about?
Cancellation of lordship, dealership.
Dealership. IOC.
Supply IOC.
IOC. Okay. There is stay order.
Stay.
Okay. Mr. Ivan.
Elvam.
Run the counsel for the petition. And Mr. T. Tapak, the standing counsel for the IOC, representing respondent number 1, 2, and 3, who submits the counter affidavit by the respondent 1, 2, and 3 have been filed. Who is respondent number 4?
All lordship, private respondent, Dusty affidavit, Dusty services already taken. And affidavit has been filed.
Okay. It appears that notice on respondent number 4 has also been served by Dusty, as indicated in the 18th office note dated 18/4/2023 on the payroll and counsel for the parties listed after 4 weeks for admission hearing. Yes.
Your Honor, the matter become infectious.
Infectious. Mr. B. Typhoon, counsel for the petitioner, and Ms. P. Pong, government advocate for the state. Mr. Typhoon submits that the petition will become infectious. For failure of the submissions made, the petition is still dismissed as infectious. Interim order passed earlier, if any, is still vacated.
Obliged.
Lordship, here I'm appearing on behalf of Mr. N. Padaya. He is currently absent and he has submitted his leave of absence. So kindly this matter may be.
What is the matter about?
Lordship, I am not aware. I was just telephonically informed that he won't be able to appear. My name is not there in Wakalatnam also.
Mr. Gyatso, what Gyatso? B.
T. Gyatso.
T.
Yes.
T. Gyatso, counsel appearing on behalf of N. Father, who prays for an adjournment. None appears for the respondent. And we have the and is prayed for the Mr. Gyatso and counsel listed after 4 weeks.
Obliged.
May read minor. My lord, here respondent yet to file their affidavit.
Yes.
Your Lordship, some more time will be given. We have not received instructions from the department. Your
What
Lordship.
is the matter about?
This is a illegal dumping in between 14 to Anya Gate. Not against the construction of the road, but illegal dumping.
Dumping must have been.
Yeah, out of their illegal dumping during this rainy season.
That illegal dumping must have been over by now.
Now, my lord, out of their illegal dumping, and our paddy fields, garden has been damaged.
You are seeking compensation.
Yes. I have filed an additional affidavit also, my lord.
Who is respondent number 5?
Respondent number 5 is the private respondent who is executing the construction work of the road. my lord.
Notice says not. You are supposed to take press steps.
My lord, I may be allowed to take press. Earlier, I had take a step up with the private respondent, but that was misplaced somewhere, my lord. So I could not able to produce the record.
Mr. N. Tazil, counsel petitioner. Mr. Ms. P. Pangu, government advocate. Representing which respondent?
3 and 4, Your Lordship.
3 and 4.
Yes, Your Lordship.
Okay. Before that, D. Kamdu. Standing counsel of the LM for respondent number 1. One only.
One only, Lord.
You represent 2, 3, and 4. Huh? Then the council, then the state council Press for, how much time?
At least 3 weeks time may be given here, that's it.
Press for 4 weeks time for filing, 3 weeks time for filing of the condo affidavit. Also, in view of the office law dated 11/7/2020, Mr. Tazi, and counsel for petitioner, also press for and is granted 1 week time to take place steps for service on notice of respondent number 5. A registered post with any as well as the usual process. Within a week, I said, listed after 6 weeks.
All right, my lord.
Here also, my lord, affidavit is not yet.
Yes,
My lordship, my lordship. We have received our instructions, my lordship. We
you have
will
received
file
the
it.
instruction.
Yes, my lordship.
So,
2 weeks may be given.
what is the matter about?
My lord, this is a initiation of criminal proceedings against the petitioner while discharging his functions as a Gaombura.
So, that Mr. Ji from the counsel for the petitioner and Ms. K. Wangmo, another government advocate.
For 1, 2, and 6.
For respondent 1, 2, and 3.
1, 2, and 6.
1, 2, and 6, who submits that she has received instruction.
2, 3, and 5.
Just who submits that she has received instruction to file a counter affidavit. Good stuff. Also had Ms. L. Hage, another counsel. You have for APP?
3, 4,
Huh?
3, 4, and 5.
APP for
We
respondent.
also have
3.
CD with us also.
4,
3, 4, and 5.
5. You will file affidavit.
And Lordship, I have the CD Lordship with us.
You have the CD.
Yes, Lordship.
I pointed out on the
Why
last
the- why
occasion
is
also,
it
the
in the
issue
same?
raised has nothing to do with the city.
Okay, all right. Let's see. In view of the and as faithful by Ms. Wang, the counsel for the London Estate Council, listed after 3 weeks for filing of a counter affidavit.
All right.
My lord, service report is still waited.
Yes.
Yes, the steps upon respondent is still waited, my service report.
24. Yes.
Service report is still waited, man.
Waited.
Yes, ma'am.
24. How many respondents?
Responding. Four, my lord.
4 respondents.
Yes, ma'am.
Unserved notice. You have taken steps by registered post only.
Yes, my lord.
You again take steps, okay?
Yes, ma'am. My lord, we have taken fresh steps on 22/5 of 2023, ma'am.
22/5.
Yes, my lord.
But it has come back. Addressee not found.
Yes.
In view of the office note dated 11/7/2023. Mr. Diado.
Diado.
Learned counsel for the petitioner, press for and is granted 1 week time to take fresh steps for service of notice upon respondent upon our respondents 1 to 4.
Yeah, 1 to 4.
By register post with AD as well the usual process. Listed after 6 weeks.
Achha.
You take my ordinary process also.
Okay.
Huh?
I could respond.
What is this IAPO?
Copy of the I is not with me, madam. It was for delay.
Non-obvious for the petitioner. Heard we study for council for which respondent?
Madam, 120.
120. You have never listed after. 2 weeks.
Lordship, on behalf of respondents 2 and 3, we have filed our affidavit. On behalf of 4, we need time to file affidavit.
What is the matter about?
We have received the instruction.
So the petition has been filed for a direction to the respondent authorities for releasing the salary of the petitioner, which has been withheld for a period of 2 years,
2 years.
from February 2020 to March 2022.
What have they said in the affidavit? They've said they'll release or not? No.
In the affidavit, they've put the whole entire responsibility over the deputy director of Jumlo Farm, which is actually the case.
Deputy director.
Deputy director of Jumlo Farm was the
Jumlo
one who was
Farm.
in.
That is respondent number 4. On behalf of him, we have to file, your
Okay.
lordship.
Have you received instruction?
Yes, your lordship.
How much time?
1 week, your lordship.
Huh?
Within a week, your lordship will
Okay.
file. After a week, maybe.
Not Ms. T. Vitel, counsel for the petitioner, and Ms. R. Russell, government advocate, representing all the respondents who submits that counter affidavit where the respondent 1, 2, and 3 have been filed. And an instruction to and Paragraph's comment for filing of a counter affidavit by the respondent 4 have also been received for which he pressed for and is granted 1 week.
Lordship.
1 week time. Was listed after 2 weeks.
No, 1 week.
Huh?
Because the matter has been pending for quite a long time, since
Okay.
last year, 1
Okay.
week.
After 1 week.
Okay, pleasure.
My lord, matter may be possible for some time. My senior is on the way, and I don't have the brief also.
What is this matter?
Matter, my RS, my second April.
I will say what order is to be passed today?
Lordship, I am appearing for the respondent number 22 to 26.
You have put respondent number?
22 to 26.
22 to 26. What is to be done today?
Yes,
What
my
order?
lord.
What order?
My lord, notice has been served already.
Notice has been served.
Yes. On last occasion, my lord, we have taken a step through paper publication. And the affidavit is already been filed. And my lord, as per
You're representing which respondent?
22 to 26, 27.
3 respondents.
6 respondent.
22 to 27.
Yes, Lordship.
Lordship, I've got respondent number 18 to 21.
18 to 21.
My lord, with regard to 1 to 17, respondent number 1 to 17. My lord, as per the file noting, that the JMFC of Coleraine, my lord,
Okay.
he sent some service report through mail. That the service has been already completed. Notice has been served. Lordship, give us at least 5 weeks for affidavit in reply.
In second affidavit is required. Huh? All right. Mr.
My lord, T. Lampung.
T. Lampung,
Lampung.
learned counsel for the appellant. Mr. T. Rar, Arya, T. Rar, counsel for respondents 18 to 21. And Mr.
T. Paul.
T. Pur, P-U-R,
P-O-L.
P.
O-L. Paul.
Or T. Paul.
T.
P-O.
Paul.
And Mr. T. Paul, learned counsel for respondents 22 to 27.
27.
Altogether 27 respondents.
Yes, my lord.
Oh, sure.
My lord, my humble prayer will be matter will be posted for hearing, my lord. Since the my lord, since
Yes.
This is my lord, second appeal.
Yes.
Notice upon respondent earlier served, and some of the respondent they were not appearing. So, with the permission of this honorable court, we have taken alternative steps, that is in publication in newspaper. And to that effect, we have filed affidavit also.
Where? Where is that? Hold it.
Affidavit we have filed on
Hold it. In
12
the office not dated 13/6/2023 as well as 12/7/2023.
12/6.
Huh?
12/6/2023.
What is 12/6?
Filing of affidavit date.
Oh, no, that's
Huh.
12/7/2023. Notice on respondents number 1 to 70 is deemed to be served. Post to hearing.
Better my posted to hearing.
Post to hearing after 4 weeks. If you want to file any.
This is second appeal affidavit may not be required.
Huh?
Your respondent number?
He is representing 18 to 21. He is for 22 to 27. 22 to 27, 18 to 21.
In that case, my lord, after 3 weeks for hearing. 3 weeks.
We'll post it after 3 weeks. If you want to file, file. But I don't think anything is required to be filed.
LCR in original has also come.
Records
It
have
is-
been called for.
It has come up with in the cause list with record.
Okay. Let's pray for the council, let's pray for the parties. Listed after 3 weeks. For hearing?
Hearing.
For hearing. That's all. Since all the parties, since all the respondents have been served, and the respondents number 18 to 27 are represented by their relevant councils, is this matter after 3 weeks for hearing.
Highly respect.
May I please, your lordship?
Yes.
Also in this matter, item number 30, here, my lord, I am for the petitioner, my lord. And the item number 29 is for IA for, my lord, the modifications of the order passed by the honorable court, my lord. My lord, my respectful submission before your lordship is, my lord, the transfer has been, my lord, made, done, and issued by the respondent authority within a period of, my lord, 8 months.
You are for the petitioner.
I am for the petitioner, man.
IA is by whom?
I filed by the respondent assessment.
Okay.
For vacation of the interim, there's an interim order passed in my absence.
Have you filed affidavit?
Yes, I
Affidavit.
filed affidavit also.
Now, my lord, the affidavit on the part of the state respondent is required is because the what exigencies has been caused to them for, my lord, issuing such transfer order within a period of, my lord, 8 months, my lord. So therefore, my lord, the affidavit on the part of the respondent, my lord, the state respondent authority is very much required, my lord.
Have you filed affidavit?
Lordship, in earlier the order, we have been asked to just obtain the instruction. So
Obtain instruction?
There was an earlier order, it was directed, recorded that matter shall be, endeavor shall be made to dispose of matter. And to do the needful matter, the state respondent has been directed to obtain 11 reports.
Instruction in the IA?
IA in all matter, to dispose
Which
of
order?
entirety matter. Yes, and as per earlier order, 29 June 2020.
29 June.
Yes.
My lord, once the
Observe that entire matter shall be disposed of, and endeavor shall be made to dispose of that entire matter. Because this transfer, because of this interim order.
Okay, all right, all right.
my lord, may I submit, my lord? My lord, the only ground for the, my lord, the applicant in the IA is, my lord, the only, my lord, he has been released from the, my lord, the earlier place of posting, my lord. Now, my lord, after the order passed by the honorable court, my lord, the applicant, private respondent herein has been released, my lord. He has been joined, my lord, after the passing of the order passed by the honorable court, my lord. So therefore, my lord, this is an order, my lord, the impugn order issued by the respondent authorities within a period of, my lord, 8 months. My lord, what circumstances has been caused to them for, my lord, filings, my lord, issuing such an impugn order by transferring me from, my lord, my place of postings at, my lord, Doimuk division, Jote division, my lord. After, my lord, 7 months. So therefore, my lord, at this stage, my lord, the state, my lord, the rest affidavit on the part of the state respondent is very much required, my lord. There is a policy guideline, my lord. There is no exigencies. There is no, my lord, even, my lord, administrative exigencies, and my lord, the causal reason has been assigned. Just only the transfer order has been issued while I was serving in the department for last 7 months, my lord.
Where is the transfer order?
My lord, annexure of my read petition, my lord, annexure 2, my lord. Annexure 1 is the, my lord, my earlier transfer order from where, my lord, I was transferred to the present place of posting.
Page
And
number?
Page number 16, my lord.
page number 15 is the, my lord, my first post transfer order, my lord. It was on 20th October 2022, my lord. On my name is at serial number, my lord, 4 from Yazali divisions to Balijan subdivision, where I'm, my lord, presently serving. And the impugn order is page number, my lord, 16, annexure 2, my lord. Just, my lord, within short span of, my lord, 8 months. And my lord, my serial number is at serial number 1, Lishi Oi A, Balijan subdivision 2, my lord, ASW, Doimuk division. Existing, against existing vacancy, my lord. And the private respondent number 4 is at page, serial number 2.
You have been given a better place.
My lord, admittedly, my lord, this is the things, my lord.
The government must have say which officer is to be placed where.
True, my lord.
So let
My lord,
them-
rest we are not querying, my lord. Rest is, my lord, the entire thing is, my lord, is lordship has already seen. My lord, only the thing is, my lord, there is a for policy guideline, my lord, for transfer and posting of the, my lord, officer. Just I have completed, my lord, 7 months.
Policy guide, the status of the guideline, you know.
My lord, admittedly, my lord, but then how, my lord, this has been executed, my lord, that has never been, my lord, my lord, disclosed. That has not been intimated, my lord. But only in violation of the policy guideline, my lord. Of course, there is a policy guideline, my lord. If it is enforceable or not, my lord, it is one subject aspect, my lord. However, my lord, at least that has to be taken into consideration.
What is there?
Lordship,
Let them come with the affidavit so that, my lord, I can give appropriate reply. My lord, only the photocopy, my lord, original may be called for, my lord. That is the photocopy, my lord, which has been submitted by the Learned Council for the state.
Today, every this e-file is there, e-office, that is.
My lord, office record may be called for, my lord. I have also, my lord, filed RTI applications for before the authorities.
In this,
One by one, slowly.
My lord.
Well, nothing can be decided in haste.
My lord. So, my lord, here, my lord, I have filed the RTI applications for the punishing of the office note, my lord, and that only copy my lord, is still pending, my lord. So, therefore, at this stage, my lord, let them come with the affidavit, number one, my lord, and the second, my lord, the LV, my lord, available with the, my lord, the records. That, my lord, how that exigencies has been caused to the respondent authorities by for issuing such impugn order.
No, it is for them to decide.
Exactly, my lord. Therefore, my lord, affidavit of the arrested respondent is very much required, my lord.
Yeah, what is there in your instruction, Mr.?
Lordship, in the, no, I have just marked as page 3, Lordship. That was the earlier proposal, Lordship. The proposal by, it was the proposal for transfer of posting of all the officers here. And it has routed through various officers and up to the chief minister. And thereafter, the impugn order was issued, Lordship.
My lord, within a period of 2 weeks, let them file with affidavit, my lord.
My submission, my lord. This transfer, my lord, the petitioner, my lord, he has not been transferred out from different division. It's the same division, and the same division only, it is a shifting of the office only. The Balijan subdivision is under the division, and he has come from Bali Doimuk under the division of Doimuk, and he is posted there in division itself. It has not been case that he has been transferred out from the station. And the same is just shifting of the official. And in that case, man, even within a day also it can be transferred. Even for that, there are numerous decisions of the High Court that even region is not required to be recorded for shifting within a division.
It is well settled law. My lord, table to table transfer is also a transfer. Even if it is transfer within the table, my lord, within the office room, my lord, if it is also counted to be a transfer. My lord, my submission, my lord, submission is what I am submitting is, my lord, at least, my lord, the reasonable opportunity should be given so as to serve me at least complete the, my lord, the tenure. My lord, wherein, my lord, earlier it was 3 years, my lord, that has been reduced to 2 years. Now, just I have completed, my lord, 7 months. Within a period of, my lord, 8 months, this impugn transfer order has been issued by the state respondents. My lord, what exigencies has been caused to them for, my lord, issuing such impugn order, my lord. So, therefore, my lord, at this stage, my lord, my respectful submission before your lordship, my lord, let them come with the affidavit so that, my lord, entire things can be, my lord, clarified. My lord, in the meantime, my lord, I may be given, my lord, such opportunity. My lord, what exigencies has been caused to the state respondent. My lord, that much only, my lord. So, my lord, within a period of 2 weeks.
You are referring to what were you referring to?
Lordship, page number 3. That was
page number 3.
Lordship. Page number 3. It is from the office note that it was proposed on 9/6/2023. So it's not only the petitioner, but there are 3 more other officers, Lordship. So it was the proposal, and so thereafter it went up to the Honorable Chief Minister, and then from there it came back, Lordship.
See, it is appreciated that you have been transferred before the normal tenure of 2 years within 8 months. All those are there. But government must have the officers of their choice.
And that to make a fair submission.
Otherwise, how can they implement their policies?
My lord, to make a fair submission before your lordship is, my lord.
You say, I have to be normally kept in a place for 2 years. And for the 2 years, you will not listen to your boss, which is the government.
True, my lord.
Then there is a disruption in the policy.
Or at least, no, but that policy has been, my lord, at least policy guideline has been framed by the state
And
respondent.
you
my
have
lord.
been, and see, you have been given, it's not that you have been transferred out in some malevolent excess of power, or you have been transferred in a very interior place, causing you an inconvenience. They have been given in Doimo.
My lord, that part, my lord, we are, my lord, not.
So under such circumstances, we may not like to interfere.
My lord, at least the affidavit so that, my lord, fair justice can be delivered. My
No
lord.
right
So-
of yours violated. No inconvenience caused to you. There is no malice on the part of the respondent authorities. Then why should we?
My lord, it is also, my lord, amounting to frequent transfer. It's because, my lord, I've been only transferred in the present place of postings in the year 2022, my lord. My lord, just I've completed 8 months, 7 months. And within a period of 8 months, my lord, I've been transferred, my lord. So therefore, my lord, we are not, my lord, having any, my lord, issue against the, my lord, private respondent. My lord, the issue is under what circumstances and what exigencies has been caused to the state respondents for issuing such impugn order, my lord, within short span of 7 months. So therefore, my lord, at this stage, at least, my lord, 2 weeks time will be granted to file the affidavit at least by the state respondent, so that, my lord, it can be, my lord, decided, and the entire things can be, my lord, adjudicated on merit, my lord. And moreover, my lord, may I pray that, my lord, at this stage, my lord, the original case that, my lord, records may be called for, my lord. I have filed the RTI application before the, my lord, the concerned authority also, my lord, that is also pending, my lord. Or otherwise, my lord, if even if, my lord, if it, the 2 weeks time may be is granted, my lord, otherwise nobody is going to prejudice, my lord. We are in the same position, my lord, not without affecting any other, my lord, officers.
My problem is I could not get even my salary because of the interim order, and my last pay certificate has been sent to the division, Doimok division from Sagali, and I'm in hanging position. And moment when I joined their Doimok division, the interim order was not made available. I had no knowledge of it, and ultimately I'm victimized.
Of course, my lord, that will be adjudicated, my lord,
And
where the payment has to be received, my lord, salary has to be received.
Almost at the verge of retirement, and under such circumstances, I've been put such stress situation. Even I cannot get my monthly salary. And just with this decision, my lord, allow my lord, I'll press my.
We'll
Yes.
come back after 5 minutes. What is to be done?
My lord, in that case, if otherwise, as per last order, my lord, it has to be decided. In case, any case, this matter cannot be disposed of, then my IA has to be had. My IA is for vacation of the interim order. Because of the interim order, I'm facing great problem. 58 years old at the verge of retirement. I'm facing extreme harassment. I'm not getting my.
What is your age? What is your age?
My age is
Huh? It must be in the affidavit.
Yes.
Huh? You don't have a, you are 51.
Only this contains an entire manner is only argument that he has been transferred before completion normal tenure. Now, as Malone has rightly pointed out, the guidelines has no initial reform. And it is within the same division, only shifting of office Malone.
Where are you now? You are in the Lepurium.
My lord, I have been released from Lepurium, my lord. Now, when I already joined the Doimuk division on 22 June, my lord. On that point of time, I was not aware, even it was not made known to the division also, my lord. And after joining, my lord, it's come to know that they have there's interim order, and because of that, although my last pay certificate LPC has been sent to as per transfer order to the Doimuk division, but I could not get salary because of the interim order this month. So, and training is also have a 22. In case my learned friend, my petitioner insists for filing counter affidavit, although it was made clear in earlier order that whatever he required to file has to be filed in time, and for disposal, even that record was filed. In that case, my IA may be taken up. Consider that. Neither I am there and neither nor I am here. In between, I am in hanging position. It's already there. It's already called for. It's already there. E-file, how there can be original matter? It is yet printed out, downloaded from the e-file manner. It's only copy there about it. We know. It is everywhere now. It's become paperless in the entire department, especially in Tamil. There is a record. I don't need it. It's kind of a big family. So, come in additional affidavit that is required. Because you will apply for that RTA or
And that apart from my lord, if the petitioner is, my lord, the private respondent herein is at the verge of the retirement, he is the fittest persons to be transferred at the place of posting, my lord. ASW, my lord. My lord, he is the only fittest persons to be posted there.
Who is
My
to
lord,
be
how?
posted where? It is.
Exactly, that has to be decided
the
by the state
authority.
respondent, my lord. That's why, my lord, my submission is, my lord, the state respondent is the, my lord, the sole authority to, my lord, decide who is to be posted where. My lord, therefore, my lord, the affidavit on the part of the state respondent is very much required, my lord.
In the writ petition, my lord, the entire pleading is only on the premature transfer within 8 months. That's only.
At least a time, maybe at least reasonable opportunity, my lord. Otherwise, my lord,
You intend to file affidavit?
Lordship is already here in there also, Mr. Lordship.
What?
Already is there in this record also, Lordship, how it was initiated. And here also they have also reported. He has
My
not
lord,
been
that,
transferred to any
my
other
lord,
division, but just shifting the responsibilities only, Lordship.
my lord, that,
Same division.
my
Which
lord,
is jurisdiction
my
of
lord, that
PWD.
instruction, my lord, even I am not, my lord, having the opportunity to, my lord, go through, my lord. That is the only, my lord, the photocopy, my lord, which has been taken out, take a print out copy from the, my lord, the maybe office record, my lord. But maybe at least if such is the position, my lord, at least I could
You
have-
file affidavit, whatever
Yes,
you
ma'am.
want to say within a week?
Yes, ma'am.
Within a week, we'll try, but it may not be possible, Lordship.
We'll take it up to 2 weeks.
My lord, in that case, my lord, my submission, my lord,
If they don't file affidavit within 2 weeks, we'll dispose of on the basis of this instruction.
my lord, 2 weeks, my lord, ultimately sufferer is me, my lord. I'm suffering, my lord. And this is, my lord, within the division only transfer, my lord. Petitioner has not been transferred out of the division, my lord. It's shifting the office only. And for shifting of the office, my lord,
That is the contention you have raised in your affidavit.
Yes, madam. I've raised it specifically, madam. Reason is not required also. And there are series of division bench of this court, madam.
Let us see one decision of the division bench of this court.
Yes, madam. Our, madam, 2003, 1 JLT, madam. Well, that is within one day, madam. First 2008, first answer.
2000 कितना?
It's 7, 8, 6. There are 8. In the instant case, what is significance that the writ petitioner, although was ordered to be prematurely transferred before completion of 3 years tenure in the post in question, the same transfer was not to any other place or station, but only to the another office in the same place.
Paragraph 8.
Yes, ma'am. 8.
In the above context.
No, my lord, 2008 UGL
786. Yes.
Paragraph 8, ma'am.
8. Yes.
In the instant case.
No, it is in the above context.
My lord, 786, ma'am.
786.
Page number
Ranjit Chandra Burman.
Yes, ma'am.
State of
Assam Basa, Ranjit Chandra, yes.
Yes, Burman.
And the page number is
just
788, ma'am.
Yes.
Para 8, ma'am.
Correct. In the instant case.
What is of significance that the writ petitioner, although was transferred to prematurely transferred before completion of 3 years tenure in the post in question. The same transfer was not to another place or station, but only to another office in the same place. Requirement of the recording justification for transferring staff before completion 3 years at one place as prescribed by the notified norms cannot be understood to apply to the transfer where transfer does not involve movement to a new place of work, new place or station. When transfer is to another office in the same place or station, judicial intervention may not be justified to such transfer order for alleged breach of prescribed norms of recording justification. This is also the division bench. And another matter.
Yeah, you will have to move from Balisam to Denmark.
Now, this is malleable. This is, it's shown to be malleable. Practically malleable is under same division one. Or the shifting of the office manner. And 2011 manner, 4 GLP also there. This also division bench.
Let us see.
2004, 2011, 4. Paragraph 11.
Yes.
Admitted fact is that though the writ petitioner has been transferred from one office to another within a short period of 6 months, but at the same time, there's a no change of station. Both the offices are situated in the Guwahati city. Besides this writ petitioner has further admitted the fact that both the post which he was occupying prior to the transfer and transferred post are equivalent, except the nature of duties and responsibilities. The other admitted fact is that when writ petitioner was transferred from the Nagaon to Guwahati within a period of 5 months, no eyebrows were raised by the writ petitioner. In other words, the writ petitioner readily accepted this transfer to prior posting at Guwahati. On the basis of this conduct of writ petitioner, the London additional AG complained that the petitioner cannot be allowed to approbate and reprobate. It is certain position of law that order of transfer of the government officer is no doubt justifiable, but such transfer order can be interdicted in rare and exceptional case. Globally, transfer order can be interfered with if such transfer order was issued by the authority not competent to do so, if there's a violation of history rules, if there's a gross discrimination between writ petitioner vis-a-vis similarly situated officer employed, if transfer order is actuated by malafide. In the case before us, neither there's any challenge to the competency of the appellant to issue the transfer order, nor is there any allegation of violation of history rule. There's also no allegation of discrimination between the petitioner and similarly placed officer. Presiding, impugned transfer order has been assailed only on the ground of non-adherence to the OM dated so-and-so, which is calculated 3 years as a normal tenure of an officer employed at a particular station. It has also been pleaded by the writ petitioner that no region has been assigned to transfer the writ petition from one place to another within a short period of 6 months. The other ground to challenge the transfer order is that the same has been issued at the behest of respondent so-and-so. As such, it is amount to malafide action. 40 money. An identical issue of transfer and transfer of an officer from one office to another in the same station at Guwahati, and that too before a normal tenure of 3 years, came up for consideration before this court in the case of just relied matter, in the case of judgment of so-and-so matter. Now, in this judgment, the division bench had also taken consideration of the observation made by Honorable Apex Court in the case of so-and-so SL Awas, reported in so-and-so, that there's no obligation for an employer to justify through a reason an order of transfer and interference of the board in the transfer order on the ground of lack of assigning reason would be unjustified. In this case also, the Honorable Supreme Court has considered a transfer of the officer in violation of the government guidelines, which provide posting of husband and wife at the same place as far as possible. Their lordship observed that while ordering transfer, there's no doubt the authority must keep in mind the guideline issued by the government on subject. However, guidelines do not confer upon the government employees a legal enforceable right. Now, regarding the guideline transfer and posting guideline has no strict enforcement. On the basis of that, no right accrued. That is also in the other division bench in Kalyan Singh 2006 has also been there. This is regarding within same station, even that for the same division, recording of division is not there because it's just shifting of office only and the same division. Had we been transferred out from the Doimuk division, then that could be a different case.
So we dismiss.
In that case,
58 years old, let him stay for some time at Balizan and retire.
2000.
Huh? My lord. He's 58 years old, let him stay in Balizan for some time and retire from service.
That part, my lord, I may be allowed to make my submission, the reply to that part, my lord.
Which one?
My lord, the submission and the contentions raised by the my lord, the private respondent herein, my lord. So therefore, my lord, may I pray that my lord, matter may be in such situation.
No, but you don't deny that this Balizan subdivision is under Doimuk division.
But my lord, the place and my lord, the workplace and the location is my lord different.
Yes, yes,
My lord,
because
of course, it is within the my lord, within Papum Pare district, my lord, admittedly, my lord. But then my lord, the division is different, my lord.
No. It is.
My lord, so, I'm sorry, division is same, my lord. The work, my lord, where this A has been fostered, my lord, petitioner and the private respondent has been fostered is my lord quite different, my lord. It is one is at Balizan, one is at Doimuk, my lord. Balizan is my lord that side, my lord, bordering to the Assam, my lord.
Guwahati is as big as from Doimuk to Balizan.
Exactly.
That is the only difference.
My lord, that part, my lord, only my lord, the rest I have already my lord made my fair submissions. That my lord, rest we are not querying about, my lord. Only thing is that my lord, what exigencies has been caused to them to my lord the issuing such impugn order, my lord. That is the my lord, my submission, my lord. So therefore, my lord, at least my lord, let them come with affidavit so that my lord, I can review it, my lord. It is the only my lord, the state respondent, my lord. Even if such is the position, my lord, of his own choice, my lord, he cannot, my lord, my lord, stress upon for postings at his chosen place, my lord. It is also in respect of my lord, the private respondent.
This is what the contention of the petition that he are insisting upon that he should be posted where he was there.
But he cannot, as a matter of right, also, my lord, he cannot claim private respondent number. Private respondent cannot also claim, my lord, that he has to be posted at where.
I would rely the government law case, my lord, 2004-11. That's for that's the 2004-11.
Yes, but that is already settled position, my lord. We are not, my lord, on that.
By the statutory rules, etc.
Yes, madam. There are 7A. There are 7, madam. It is too late in the day for a government summon. Government law. There are 7. It is too late in the day for any government servant to contend that once appointed or posted in a particular place or position, he should continue in such place of position as long as he desires. Transfer of the employees is not only an incident inherent in the term of appointment, but also implicit in the essential condition of service in absence of any specific indication to the contrary. In law governing condition of service, unless order of the transfer is shown to be outcome of modified exercise of power, violating any statutory provision, act or rules, or passed by authority not competent to do so, an order transfer cannot likely be interfered with as a matter of course or routine for any or every types of grievances sought to be made. Even administrative guideline for regulating transfer of a containing transfer policy at the best may afford an opportunity to the officer or the servant that have to approach their higher authority for redress, but cannot have the consequences of depriving or denying the competent authority to transfer a particular officer or servant to any place in the public interest, and as is found necessitated by exigency of such, as long as the official discharge is not affected adversely or there is no infraction of any career prospect, such as seniority, scale of pay, secured annulment. This court has often reiterated that order of transfer made in transgression of the administrative guideline cannot be effective as they do not confer any legally enforceable right, unless, as noticed, some should be vacated by modified or is made in violation of any statutory provision. A challenge to the order of transfer should normally be assured and should not be encountered by the court of treatment as they are appellate authority over such order, which would assist the nicety of the administrative need and requirement of the situation concerned. This is for the reason that the court of treatment cannot substitute their own decision in the matter of transfer for that of the competent authority of the state, and even allegation of malafide when made must be such as to inspire confidence in the court or are based on concrete material and ought not to be entertained on mere asking for it or mere consideration born out of conjectures or surmises, except for strong and convincing reason. No interference would be ordinarily made with an order of transfer. And my lord, SR Abbas Matter, 1993, one paragraph. 1993, 4 and 6. Page 3. Para 7.
Yes.
Para 7. Who should be transferred where? It's a matter for the appropriate authority to decide. Unless order transfer is vacated by the modified or is made in violation of any institutional provision, court cannot interfere with it. While ordering transfer, there is no doubt the authority must keep in mind the guideline issued by the government or subject. Similarly, if the person made a representation with respect to this transfer, the appropriate authority may consider the same, having regard to the exigency of administration. The guideline says that as far as possible, husband and wife must be posted. This in the government, posting of husband. Now, this is what I'm relying on, insisting on this. The where to be posted, who to be posted where, it is the authority to decide that, not the petitioner. And other than only just premature transfer models, there's no any ground.
Okay.
And this matter today, this matter was fixed as consented by the parties. He was also there in the last occasion when the matter was taken up on 29th. And it was specifically directed. If any is to file a reply, he has to file within time. And because of the interim order, I'm suffering.
Since I have already filed the applications through RTI, so once the copy is published, at least I could have add some more details that how this has been initiated, as so far the reliable information is concerned, this has been done as per the at the behest of some other person, so therefore it is very fast stages and instance says we have not annexed and inflated the persons who is involved in the this issuance of the transfer of the so therefore In that case also, my lord, we'd likely to file, my lord, the additional affidavit by implementing to some other persons who has, my lord, initiated this, my lord.
Then we take a call in the IA.
Yes, ma'am. My lord, in this
Interlocutory application.
my lord, since we respondent number, private respondent as well as the petitioner is only involved in the case, my lord. So therefore, my lord, nothing will, my lord, much affect to the other party, my lord. So therefore, it is in respect of the private respondent and then.
I'm in hanging position. I'm released from the reference.
The release has been done, my lord, after the order passed by this honorable court, my lord. That cannot be a ground for, my lord, the modifications, my lord. So therefore, my lord, at this stage, my lord, at least, my lord, one time and again, my lord, my submission will be, my lord, is, my lord. At least, my lord, the respondent, state respondent's affidavit is very much requirement. My lord, a week time may be granted, my lord. In the meantime, my lord, the entire matter may be disposed of, my lord. At least, my lord, the original record may also be called for, my lord. How this has been initiated, my lord. And my lord, the rest part, my lord, I will give my submission also.
But have you seen the last order? Last order in the IA. It said that the London State Council for the State of AP shall produce the record pertaining to the impugned order, impugned transfer order dated 15/6/2023 by the next date fixed, which is today.
My lord.
On the next date fixed, an endeavor shall be made to dispose of the writ petition.
My lord.
And if such writ petition is not disposed of, the applicant shall be at liberty to press for the present application. That is what he is pressing.
My lord.
I am for disposal of the writ petition itself. But since you are seeking some time and asking the government to file an affidavit, we'll allow it, but we'll have to take a call on the IA.
In IA, my lord, may I pray that my life maybe some given some more time to my lord.
No, this is the last order.
My lord, and at least my lord, I'll reply to that, my lord, the IA, my lord. This IA has been, my lord, may I take your lordships to the IA filed by them, my lord. In fact, I have not filed my lord, the reply to this, my lord, because of this, my lord, the certain difficulty in my lord replying this IA. My lord, IA has been issued, my lord, sorry, my lord, if order of release has been issued by the, my lord, the respondent authorities, my lord, executive engineer. It is in page number, my lord, 18, annexure 4, IA, my lord. This has been issued, my lord, may I read, my lord, in pursuance of the government order issued by the Principal Secretary, PWD, Government of Arunachal Pradesh, Itanagar, by number so and so, dated 15 so and so, Sri Ghosh Tarang, Assistant Engineer C. The Leporian subdivision is hereby released from this establishment today, the 22nd June 2023, forenoon, with the further directions to report to the Executive Engineer, the Vimukh Division, AP, for his further duties, man. This was issued on 22, man. An interim order passed by this honorable court on. Again, my lord, may I take the lordships to the annexure?
It is 21, there's nobody
one.
disputing, but the fact is that this has been not made known to the petition and the private
respondent. Well, after the, my lord, after, so therefore, my lord, after the, my lord, the interim order passed by the, my lord, the honorable, by this honorable court, my lord, if the person is released without knowing, my lord, this is the responsibility on the part of the state respondents to make him communications to the, my lord, the concerned authorities not to release, my lord, there is a stay order, my lord, passed by this honorable court. So only basing on that, my lord, the duties and responsibilities can be cast upon to the, my lord, the petitioner, my lord. So after, my lord, had it been the case that, my lord, before the passing of the, my lord, the interim order by this honorable court, my lord, admittedly, my lord, he has the case. But my lord, after the order passed by this honorable court, my lord, if knowingly or unknowingly, my lord, if the person and the officer is joining his new place of posting, my lord, the overlooking is the, my lord, order passed by this honorable court, my lord. So that cannot be, my lord, the basic ground is, my lord, the basic ground, my lord, the application, the hearing, my lord, the basic ground taken by the applicant is, my lord, only that extent that he has already been released. My lord, the release was done after the, my lord, the interim order passed by this honorable court. So therefore, this cannot be the ground for the modification and alterations of the order passed by this honorable court.
Well, I'll clarify whether there's a ground for
My
modification.
lord, even his joining has been, my lord, to that extent, my lord, we have also written to the executive engineer, my lord, who has released the private respondent. We have written to the applications to him to, my lord, call him back. It's because there is a interim order, my lord. So therefore, my lord, at this stage, my lord,
In that meeting, the allegation is he has been transferred within short period, 8 months, that's all. Now, in the IA, we have specifically pleaded that that transfer is.
my lord, once
against the
IA is
not
this,
out of the
my lord,
division.
once IA is decided, my lord, no, my lord, my lord,
So let us dispose of the writ petition.
my lord, in this case, my lord, may I pray to my lord, I may be given some more time to my lord to make my
So that you
submission.
can go and appeal.
My lord,
So that you can go and appeal.
not exactly.
This
my lord,
is
it is
transfer
another
matter.
aspect, my lord. My lord, may I pray to my lord?
What had Holbeck this court for quite some time was that you have been transferred after 8 months old. Otherwise, in principle, the government can transfer any employee.
But my lord, in that case,
Even within a month or two also.
true, my lord.
And we can interfere with it only if it is issued in a malafide exercise of power and in violation of some rules, etc. Otherwise, government must have the.
My lord, in that case, my lord, so
say-
therefore, my lord, may I pray that my lord, a week time may be granted, my lord, so that I can come with another additional affidavit, my lord, to bring.
What is there?
My lord, as we have seen, this has been, my lord, once occasions, my lord, has been initiated by the, my lord, the concerned authorities, my lord, who is not at all, my lord, related. At the behest of the some authorities has been done, my lord, initiated. So therefore, the secretary, my lord, the PWD has also made a mentions that, my lord, there is a, my lord, at least, my lord, the normal tenure is not completed, my lord. That has not been taken into consideration, my lord. So therefore, my lord, may I pray that, my lord, justice should be, my lord, done.
That aspect,
My
my lord is considering this aspect, whether the violation, whether non-completion of the tenure.
Therefore, at this stage, my lord, I cannot.
And in Dilip
My
Kumar
lord,
case, my lord,
at this stage, my lord, I cannot be, my lord, in a position. I am not in a position to, my lord, flesh the argument, my lord, with regarding, my lord, that my lord, initiation of the, my lord, file.
it is the petitioner who filed the writ petition. It is honest of the, it is upon the
My
honest.
lord, therefore, I prayed honorable
To
court.
come up with
My
all
lord, I'll come with the affidavit, my lord, additional affidavit, my lord, bringing the
trade union registration, my lord, by the original, my lord, organization which was registered under Society Act, my lord. Then there is also a police complaint case. There is also, my lord, the authority of observe the registration was obtained prudently.
Just a moment. Before that, what is the procedure for cancellation of a registration
My lord,
under the Act and the rules?
notice has to be issued, my lord. So notice was issued.
Notice was issued.
Yes, my lord, it was issued. Now what
they file a reply.
My lord, notice was issued. What they said, it was received very late, or they said the notice was never issued. But we can demonstrate, although by name as a president, he may not receive it, but someone received on behalf of the president. But now there is a limitation within that period. He has to submit the reply. Now within that limitation, he has not submitted the reply. But later stage, he has submitted the reply to the show cause notice. So which was not accepted by the issuing authority, saying that it was received too late, and the grounds are given specifically in the notice itself. There were 3 grounds, my lord. Even one grounds, if satisfied.
Trade union is registered under Trade Union Act.
Trade Union Act, I think 19.
Let us see those provisions.
1920, something like that.
For cancellation.
Section 10, if I correctly remember. Oh, I have to open my paper.
You have the direct with you.
Cancellation section 10.
Cancellation of register, section 10.
Section 10. Clause B. Is your lordship got it?
Yes.
Section 10, cancellation of registration. A certificate of registration of a trade union may be withdrawn or cancelled by the registrar. Number 1 is on application of the trade union to be verified in such a manner as may be prescribed, or if the registrar is satisfied that certificate has been obtained by fraud or by mistake, or that the trade union has ceased to be exist or has willfully and after notice from the registrar contravened any provision of the act or allowed any rule to continue in the force which is inconsistent with the such provisions. It still is there. So basically here is the case, my lord, this has been obtained either by fraud or by mistake.
On this ground it was cancelled.
Yes. So by section 10B, so under this provision notice was issued to him. Now what they say, my lord, they have not received the notice, but of late they said later on they received and reply was submitted to the registrar. A registrar's contention is that the limitation was over, and because of that the representation was the reply was not accepted by the registrar. The grounds were given in the notice itself. 3 grounds, my lord, if your lordship peruse the notice. Your lordship may kindly obtained by fraud or by mistake. Now there are 2 unions in same name. One is one is registered under trade union and the another is registered under the Society Act. Now, what is important now, which this trade union or the this federation, transport federation, who registered first? Obviously, it was registered under the Society Act. Subsequently, the client of Mr. D.K. Pangin, subsequently they registered in the trade union. So, perhaps that fact was never brought before the registering authority, that there is another trade nomenclature of the issues already exists and registered under the Society Act. Now, why I'm saying it has been obtained broadly, because the president himself, he was the member of that association of that which was registered under the society. So he knows all the facts, my lord. So that fact was concealed before the authority to be registered under the trade union, my lord. So prudently he has registered this association, my lord, in same nomenclature, same, my lord, bylaws and everything, my lord. So after noting that, my lord, so notice was issued. The subsequent so many developed, my lord, I may not harp on that, my lord. Criminal, charge sheet and all these things, I may not harp on that, my lord. The section 10B, my lord, clarifies, my lord. If the certificate is obtained, if registration obtained either by prudently or by mistake, that can be cancelled.
What is the impugn order?
Impugn order.
Page 89.
Page 89 of the petition, my lord. As your lordship got it, annexure 14.
Yes, yes.
It's an order dated 14 September 2015. On top, my lord, withdrawal or cancellation of certificate of registration. This is to certify that the certificate registration number so and so that the 23/6/2010 granted to all Arunachal Pradesh Public Transport Federation address opposite Abe Mara JCB dealer Papun Nala district Papumpara Arunachal Pradesh has been withdrawn on bracket or cancelled with effect from the 14 September 2015 in terms of the following grounds. So 3 grounds are there, my lord. The first ground says, my lord, all Arunachal Pradesh Public Transport Federation registered under the trade union has indulged in criminal activities. They attack and ransack the local daily newspaper paper office of ECO of Arunachal Pradesh on 9/11/2012. Both Superintendent of Police, Itanagar and District Magistrate recommended for the registration of the union. This is number 1 ground. The second ground is, my lord, the same trade union has collected exorbitant membership fee of rupees 20,000 only from MS Azum Enterprises on 29/6/2010 against the actual annual membership fee of rupees 30. The third ground is perhaps most important, my lord. The same All Arunachal Pradesh Transport Federation had registered itself under the Society Registration Act 1860. After changing its nomenclature of Arunachal Pradesh Motor Transport Federation, and the same federation has again been got registration itself under the Trade Union Act 1926 in the name of Arunachal Pradesh Public Transport Federation. Thus, there is an element of prudence in the registration process. Fourth may not be important, Mala. These are the 3 grounds cited by the registering authority for cancelling the registration given to Mala this under the Trade Union Act 1926.
But they say members are different.
Members may be different. Malo, see the nomenclature. Nomenclature is same, purpose is same. Members may be different, Malo. No doubt about that. Members are different, Malo. You also have to see the nomenclature and purpose. The purpose is same, the nomenclature is same. Members admittedly is different. But main question is, can there be two organizations in same nomenclature with same purpose, which is neither permissible under the Society Registration Act nor in my lord the Trade Union Act. My lord.
Which is that provision?
Section 10, my lord. 10B, my lord.
You should obtain with fraud or mistake.
Mistake. Because this fact was never brought before the registrar authority, my lord, that there is already existed, my lord. So that information are perhaps not brought before this authority, my lord, under the Trade Union. Because of that, my lord, he issued, my lord, that license, my lord.
So shall we come back at 2?
My lord, all right.
But I have not been able to understand. Fraud or mistake. Trade union is for what purpose in society?
Basically, trade union for the industry having big factories, my lord, for the welfare of the workers, my lord. But we don't have that much, my lord, industry in Arunachal Pradesh. There is also, my lord, yet admittedly, under the Trade Union Act, there is appeal provision also.
Next week, I have some. Because I have not even started my argument. My argument is on a totally different basis. 24, if it is convenient to others.
Yes.
The first hurdle we have to cross whether there can be a two, my lord, association having the same nomenclature. My lord.
With greatest respect, that is not even the issue in my reputation.
It was
It's
just
not.
It was just a
Maybe not, but as an issuing authority, that is the most important.
No,
my lord.
it was just a preliminary.
3 writ petitions were allowed, my lord, because I was not given an opportunity. Maybe whatever my learned elder brother is saying may be correct, assuming. But I have to be given an opportunity to rebut that. That opportunity was not given. That is why this Lordship has interfered 3 occasions. The same thing has happened.
But if we have to hear the matter, the petitioner will have to begin.
Yes.
I'm sorry, my lord.
If we have to hear the matter, petitioner will have to
Yes.
have the right to.
Absolutely. Both they have to
begin.
argue first.
So it
Then I have
was
to.
just some
My
sort
lord.
of inquiry, what kind of the nature of the case it is. The question is whether should we continue at 2 or
If
as
it is
is
not
proposing on
inconvenient to
24.
my
My lord,
learned friend.
I don't have any objection. But
Let
my two brothers decide. My lord. If they agree, my lord, I'm ready. My lord.
Next week, I have some difficulties. Any date week commencing from 24. Next week I have to be out of station for 3 days.
At 2, let us.
Next month. 24, any date, 24.
This is pending since 2015.
Yes, lots of counsel changed in respect of my learned friend's client. That's why.
What is open to any side? At 2 also, no problem.
Let it be after 24 days, any date convenient to my learned friend.
That case 26.
26.
Is what day? Which day?
Wednesday.
My lord, not Wednesday, my lord. I have some partially. Any other day, either 25 or 27. Wednesday, I have my own problem.
Yes.
Either
27.
25 or
I have no
28.
28. All right.
Why 28 is a Friday again?
I have no any date after 20.
31st.
There is Monday.
Monday. My lord.
Yes. 31st?
Well, no problem. No issue. 31st. Right.
Prayer of Learned Council to the parties listed on 31st July.
Problem.
Highly impressed.
Aku next week.
इसको बंद कर दो, रेस्पॉन्ड कोई नहीं है। इसको बंद कर दो। Respondent नहीं।
आइजल हाईकोर्ट पेमेंट नया हाईकोर्ट जो बन रहा है ना ये महीने से इनोग्रेशन है
वो छोटा है।
हाँ आइजल
वो छोटा है।
नहीं बहुत बड़ा है 4 story एक्सपेक्ट 1.5 रेसिडेंस ना
Yes.
Fact of the case is that there was a dispute between the petitioner and the respondents. And pursuant to that, a Keba decision was passed on 29/10/2021. That is at page 26. Now, against that Keba decision, which was passed against us, we prepared first appeal. And that first appeal order was also passed against us.
First appeal before where?
District Judge Alo. And then we prepared second appeal before this order of court. Page 62. Now, after hearing the parties, the matter has been kept for reserved for judgment and order. Page 65 would be the order.
Yes.
Now, what happened, my lord, during this pendency of this proceeding, my lord, this ADC, my lord, who is the executing court, my lord, authority, my lord, of decision passed by the village authority, my lord. They have passed an order, my lord. Type copy would be page 67, my lord.
Yes.
They have fixed a meeting on 10 January 2023, my lord, and asked and directed us to appear before the ADC Michuka, my lord. Page 67, my lord, type copy. Now, what happened, my lord, page on 9/1/2023, my lord, we submitted a representation. We submitted a representation, my lord, before the ADC, my lord, requesting him to, my lord.
What is page 67?
Page 67 is the order, my lord, directing us to appear in the office chamber of the ADC Mechuka, my lord, regarding the dispute, my lord.
It was on 10 January.
Yes, sir, which was fixed to be on 10 January, passed on 5 January, my lord. It was scheduled to on 10 January 2023, my lord. Now, on page 68, my lord, on 9/1/2023, we have submitted a representation, my lord, by stating that our second appeal is pending before this honorable court, my lord. So matter may be kept in abeyance, my lord. This application will be is justified under section under order for 21 Rule 26, my lord. CPC, my lord. Now, our matter was kept in abeyance, my lord, for months, my lord. Then, my lord, what happened thereafter, directly on page 64, my lord, of 74, my lord, on 18 May 2023, my lord, the first impugn order was passed, my lord. Now, my lord, fourth paragraph, my lord. In the fourth paragraph, our representation has been, my lord, reflected, my lord. Further, no representation shall be accepted for adjournment, and in the event of absent of any party, execution shall be done ex parte, my lord. On this 18 May, my lord, the demarcation of land was fixed on 22 May 2023, my lord. In the third paragraph, it has been written, my lord. Now, for execution of the judgment, the Kaba body members with magistrate, police, and Mandal will demarcate the land on 22 May 2023. My lord, what again thereafter on 22 May 2023, my lord, we requested the ADC Mechuka, my lord, to defer the matter because our appeal is pending, my lord, again. My lord. Now he has, and then he gave us 10 days time to procure interim order from this honorable court, my lord. Now, again on 35/2023, page 75, my lord, we again submitted a representation, my lord, requesting for suspension of execution procedure.
There was no stay order in the second appeal.
Yes, my lord. And my lord, thereafter on 4 July 2023, my lord, the final order, my lord. Here, my lord, in the my lord, second last paragraph, whereas more than 30 days, my lord, or third last paragraph, my lord, whereas more than 30 days have passed and Sri Tago Pochung and party has not been able to provide any stay order from this honorable court Itanagar bench till today. Hence, the demarcation of Yorko land has, as per the Kebang decision, shall be carried out on 14 July 2023, and no further extension shall be entertained. 14 July is tomorrow. My lord. Against that, my lord, we have also submitted a written objection, my lord, on 11/7/2023.
Which is the impugn order here?
The main impugn order is page 76, my lord.
76.
Yes, my lord. 4 July 2023. My lord, what I see from this impugn order, my lord, no proceeding was held, my lord. Directly this order was passed. But at least, my lord, as a principle of natural justice, my lord, there has to be some proceeding, my lord. Directly, the executing court cannot pass order for execution, my lord, of Kawa decision, my lord. And we have some sentiment with our, my lord, what happened, my lord, our land has been divided into 3 parts, my lord. 30%, 30%, 40%, my lord, by the public leader, PI, ex-ASM, my lord. They claim to be the, my lord, village authority had passed the Kewang decision, my lord. And that is under challenge, my lord. And the order has been reserved by the Supreme Court, my lord. We are saying, my lord, in our second appeal, we have said, my lord, this PI, ex-ASM, public leader, they are not the village authority, my lord. At least, my lord, before passing this order, my lord, for execution, my lord, a proceeding has to be taken by the executing court, my lord. Straight away, this order cannot be passed, my lord.
What is wrong with this?
My lord, section 45, my lord, 2, my lord, the latest amendment, my lord. May I read, my lord? Section 45, 2B, my lord.
Where it is?
In the new amended Arunachal Pradesh Civil Code Amendment Act, 2022.
Yes.
2B, my lord. Section 2B. The concerned deputy commissioner or the assistant commissioner, as the case may be, on receipt of such application, may call for records of the order or decree of the village authority and execute or enforce the same by following the principle laid down in the Code of Civil Procedure 1908 in spirit. Now, look, CPC says, my lord, at least, my lord, as per, my lord, section order 21, rule 13, my lord. It says, my lord, may I read, my lord? Application for attachment of immovable property to contain certain particulars, where an application is made for attachment of any immovable property belonging to a judgment debtor, it shall contain at the foot a description of such property sufficient to identify the same. And in case such property can be identified by the boundaries or numbers in a record or settlement or survey, a specification of such boundaries or numbers. Description of the property has to be given by the applicant. And order 17 also, my lord, says, my lord.
Description is there.
Description is there, my lord, but there has to be some application, my lord.
Application?
Application, my lord, by the decree holder, my lord. And then section 47, my lord. Section 47 of the CPC, my lord.
Why was the stay refused in the second appeal?
My lord,
Why was the stay refused in the second appeal?
it was not refused, my lord. It
Then
was.
where is the stay?
My lord, we prayed for the status quo. My lord, what happened? The court, my lord, this court, my lord, have stated that it will pass the judgment and order, my lord, uniformly, my lord, directly, my lord. The IA was so not disposed of, my lord. In the order itself, it is reflected, my lord. It is linked with the main case, my lord. My lord. Page 62, my lord. Page and page 63 would be the relevant, my lord. Link case IA, my lord. It has not been disposed, my lord. Link case, my lord, IA civil 254 of 2022, my lord. It has not been disposed, my lord. But for the interest of justice, my lord, what I pray, my lord, this impugned order may be stayed, my lord. At least, my lord, what my prayer is, my lord, at least, my lord, some proceeding has to be held, my lord, so that a reasonable opportunity should be given to me, my lord. And moreover, my lord, this second appeal is also pending before the Honorable Court for judgment, my lord. I'm not on the merit, my lord, because on merit, my lord, I cannot plead, my lord. Otherwise, also, my lord, this Keva decision was passed without any proceeding, my lord. We have taken that plea, my lord. No proceeding was initiated. The Keva, while arriving to the decision, has taken the proceeding of arbitration, my lord. No Keva proceeding was initiated. For the interest of justice, my lord, this impugned order may be stayed, my lord. At least, my lord, a reasonable opportunity should be given to us, my lord. Of course, ADC has the right, my lord, to execute our decision, my lord. But there has to be some proceeding, my lord. Of course, sure. Due lordship to section 47, my lord, of CPC, my lord.
Yes, 47.
Section 47, my lord. May I read, my lord? Section 47 CPC, my lord. Questions to be determined by the court executing decree, my lord. All questions arising between the parties to the suit in which decree was passed or their representatives or relating to the execution, discharge or satisfaction of the decree shall be determined by the court executing the decree and not by a separate suit, my lord. At least there has to be some determination.
Why this petition is under 227?
Because, my lord, CPC is applicable in spirit, my lord, not in totality, my lord. CPC, my lord, is not directly applicable to proceedings of village authority, my lord. CPC is not.
This is not the village authority.
Yes, my lord.
This is by additional deputy commissioner.
Yes, my lord. Additional Deputy Commissioner as per AP code, my lord.
AP code.
Yes, my lord. In the AP code, there is no revision, my lord, provision, my lord. So I'm Article 227, my lord. Even, my lord, under order 21 rule 29, my lord, this honorable court can stay the, my lord, proceeding of the execution, my lord.
But 227 can be invoked
Yes, my lord.
only when the authority has acted without jurisdiction.
Yes, but it has the jurisdiction, but it is not exercising its jurisdiction, my lord. Because I should be given some reasonable opportunity, my lord. At least there has to be some proceeding, my lord. No proceeding has been held. My lord. Directly, this order has been passed, my lord.
What procedure is to be followed?
My lord, section 47, my lord, CPC. My lord.
Yes.
Questions to be
And
determined.
why did you point out order 21 rule 13?
Rule 13 also requires, my lord, the applicant, my lord, the decree holder should, my lord, submit the description of the property, my lord. It is the applicant, my lord. No such application is there, my lord.
Yeah, what is 47?
Oh, yes, ma'am. Section 47. Questions to be determined by the court executing decree, my lord. All questions arising between the parties to the suit in which the decree was passed, or their representatives, or relating to the execution, the discharge or satisfaction of the decree shall be determined by the executing court, executing the decree and not by separate suit, my lord. So there has to be some determination, my lord, as per section 47, my lord. What I say, my lord, order 21 rule 29 also empowers this honorable court to stay the execution proceeding, my lord.
What was the Kevang decision?
Kevang decision, my lord, they have divided our land, my lord, my village land into 3 parts, my lord.
On what ground?
On the claim of the respondents, my lord.
Ah.
But there was no proceeding. That's why, my lord, in my second appeal, there was no proceeding, my lord. That's why we have claimed that there was no proceeding, my lord. They have taken the statement.
Then how did the appellate court uphold that decision?
My lord, that's why, my lord, that's why
not that's why. What reason the appellate court has given?
First appellate court has given the reason that they are a village council, my lord. From time immemorial, this village council has been in existence, my lord.
So they will always be right.
Yes, my lord.
What is that? Which appellate court has said so?
In the judgment passed by the appellate court, my lord.
Judgment starts from which page?
Judgment starts from page 29, my lord. Page 54, my lord. Para 48, my lord. Page 54. My lord.
Yes. In this state.
Yes, my lord. In this state. The traditional village councils of local tribal exist since time immemorial, wherein the disputes of villages were settled as per the customs and traditions of the society. This tribal council has been given recognition in the statute with the enactment of the regulation 1945. The Regulation 1945 had empowered these councils to act as local court in their respective villages, and same has also been recognized by the newly enacted law of the State Act 2021. The traditional court normally conduct the hearings verbally, and the records of the proceedings are not even properly kept. However, with passage of time and changes in the society, including the members of the council or local court, nowadays, some of the KEBA started recording the proceeding in written and used to keep the record of such proceeding. In this regard, so and so.
All right. Right, Mr. B. Picture and counsel for the petitioner. Petitioners.
Petitioners.
This revision is directed against the order dated 4th July 2023, passed by the additional deputy commissioner, CMU district, Meshuga, by number at page 76. Why? By which order? The Kewang decision dated 29 October 2021.
Yes, ma'am.
Is sought to be executed. Also, now counsel for the petitioner submits that I proceed Kewang decision dated 29 October 2021 was challenged by the petitioner's hearing by filing a civil appeal number 01 of 2022 before the district judge Alo
West Siang District.
West Siang District. Whereby the learned district judge Alo had upheld the decision of the KEWA dated 29 October 2021 in the judgment and order dated 27/9/2022, passed in civil appeal number 01 of 2022. Poster. The judgment and order dated 27/9/2022, passed in civil appeal number 01 of 2022. However, the KEWA decision dated 29 October 2021 has been appealed, has been assessed by the petitioners in RSA 5/2022 before this court, which appeal has been heard by this court on 29/5/2023, and the judgment and order has been reserved by this court. Under the official circumstances. Since the just a minute. You should notice a return in 4 weeks. steps being taken by restricted with AD. How many respondents?
5 respondents.
As your usual process within a week, the respondents. Also, since the decision rendered by the district judge Alo in civil appeal number 1 of 2022, however, the Kevang decision dated 29 October 2021 has been upheld, is under challenge in the RSA number so and so, which has already been heard by this court, and judgment and order has been kept reserved as indicated here in above till the returnable date. The imprint order dated 4th July 2023 passed by the Additional Deputy Commissioner, CMO District of Meshuga, by number so and so, at place 76, Save State.
Much obliged.